Okay, I'm ready to get started on the current webinar presentation involving Lockout Tagout and OSHA, equipment specific as the subject matter. Before I begin, I'd like to remind everyone that the Goosmann Law Firm does engage in the practice of law, and the information that I will be discussing is not and should not be construed to constitute legal advice for any of you or your company who may be participating in this webinar. The subject I'd like to talk about today deals with the OSHA standards concerning lockout, tagout, and the control of hazardous energy. My experience as an attorney has involved working in the machine and labor-intensive meat packing and food industry businesses that, of course, do involve complicated and numerous kinds of equipment and machinery. And in that regard, my experience has involved not only serving as in-house counsel for companies of that nature throughout the years, but also dealing with OSHA at both the federal and state enforcement levels, including the state of Iowa, regarding all aspects of OSHA safety compliance, administrative review and appeal, and the whole gamut. Concerning today's topic, we're specifically dealing with 29 Code of Federal Regulations, Section 1910.147, which is officially labeled the control of hazardous energy, but for those folks who are at all familiar with OSHA, it's more commonly referred to as the lockout tagout policy under the safety standards. This, in my opinion, as well as many other people, is one of the most significant and important safety standards that employers are expected to comply with. It is considered by most as being in the top 10 most frequently cited OSHA standards, and in my opinion is got to be in the top 2 or 3 of the most important OSHA standards that employers are required to comply with. It's a concept of making sure that when people are going to work on equipment and break the plane by reaching into, on, or about such equipment that it be de-energized. So we're talking about preventing workplace injuries and encouraging employers to understand that it does require quite a bit of effort on the part of the employer to make sure that they are abiding by the lockout, tagout procedures and standards under OSHA in Section 1910.147. I'd like to quote from OSHA from that section. The standard covers the servicing and maintenance of machines and equipment in which the unexpected energization or startup of the machines or equipment or release of stored energy could cause injury to employees. This standard, being the 1910.147 standard, establishes minimum performance requirements for the control of such hazardous energy. I note in my PowerPoint that OSHA's position is that it presumes that a hazard of unexpected energization always exists during servicing and maintenance. It is OSHA's burden to prove up, first of all, if there is an alleged violation, and it has to at least show that there is some way in which the particular machine could energize startup or release stored energy without sufficient advance warning to the employee. Now, as an employer, protecting your employees from accidental startup is a necessary first step, obviously, in conducting repairs and servicing and maintenance. And employers, for the protection of the employees, are always required to take measures to ensure that the on-off devices and switches are in the off position without a chance that they will start up as a piece of equipment. In doing so, you must establish as an employer a program to control the energy that goes into this equipment. We're not only talking about electricity or powered motors, but we're also talking about stored energy, hydraulic type of energy. You'll know that when you have a piece of equipment that is hydraulically driven, pieces of that equipment, once the equipment is shut off, may still be in an upright position, and that force needs to be removed as stored energy from hydraulic equipment, for instance. So we're talking more than just electrical within the concept of lockout tagout. It is a common, perhaps, misconception by employers that they have done their job in complying with OSHA lockout tagout training by simply training employees about the need to lock out and tag out, and maybe doing so in a very general, comprehensive way when you first hire an employee, and part of the new hire training and orientation is to teach them about the concepts of lockout tagout. But my lecture today is focusing more on what is required to achieve compliance based on an extremely important decision that took place at the end of 2007 involving the OSHA Review Commission and General Motors. It was a case dealing with the specificity requirement of OSHA's lockout tagout standards. It was a case that actually had been investigated for over 10 years by OSHA and resulted in a December 2007 commission decision regarding the specificity requirements of lockout tagout as a safety standard. We all appreciate from an employer's side of things that simply having a program in place is not enough. You have to be more specific in terms of what the program is going to require of employers regarding lockout tagout. And my discussion is going to get into that aspect in light of the OSHA Commission's decision back at the end of 2007. Now, keep in mind that there is no absolute black and white blueprint to follow in terms of what an employer must do and have on hand by way of documentation and how to train and certify lockout tagout procedures. And I'll discuss why that is. But this particular OSHA review decision, people were waiting, relatively speaking, in bated breath as to how the commission would rule. And one of the important aspects of this ruling is in reference to an Appendix A that's contained in the lockout tagout procedure under 1910.147. And in a nutshell, the Review Commission decided in this case that employers are required to develop a separate written lockout procedure for complex machinery and equipment. Now we're going to get into discussing what that means in terms of a separate procedure that must be written for complex machinery and equipment. What the commission said via OSHA's allegations was that General Motors had failed to, quote, clearly and specifically, unquote, describe in its written lockout procedures the steps necessary for controlling hazardous energy and the means to enforce compliance. Now, of course, as an employer, GM was arguing that what they did have in writing was sufficient by way of how specific you have to be in a written description on how to lock out and tag out equipment, but obviously OSHA differed. And that's where you get into, it's kind of a gray area as opposed to black and white as to how specific these procedures must be. Now, this battle between employers and OSHA on specificity and to what degree lockout tagout procedures are deemed adequate based upon performance-based standards versus what is in writing is a big question. My clients in the years past, along with other employers, have always tried to argue that lockout tagout procedures are adequate in writing if the employee can actually perform correctly the procedures that must be followed in order to lock out and tag out equipment. It can't be so general that it doesn't say anything, but the bottom line, according to what employers advocate, is that, well, you can look at the written wording we've got, and it will have some procedure or specifics in it. But the main thing that counts is, can the employee actually perform the procedure correctly? And thus, employers claim that it's a performance-based standard in judging the adequacy of how specific lockout tagout procedures must be in writing. Now, you can imagine that OSHA, being the counter force in this whole argument, requires much more specificity, in their opinion, to be in writing upon which the employee is trained in order to pass muster under the OSHA 1910.147 standard. OSHA tends to take a more, and I don't mean any offense by this, a more dumbed down approach to how you must be very detailed in describing the procedures from beginning to end on how to lock out, tag out, make sure it's de-energized, and then how to re-energize the equipment versus an employer's more performance-based standard of review. So, is it a performance-based standard or something more specific in writing that is required? And I hate to tell anyone this, but gee, it's going to depend upon who the OSHA inspectors are, what the circumstances are that led them to be concerned about the issue of adequate lockout tagout procedures in your facility that, as we will discuss, must be equipment specific. Notice under 1910.147 sub C sub 4 sub 2 of the lockout standards, it states, the procedure shall clearly and specifically outline the scope, purpose, authorization, rules, and techniques to be utilized for the control of hazardous energy and the means to enforce compliance, including but not limited to the following. First bullet point, a specific statement of the intended use of the procedure, followed by specific procedural steps for shutting down, isolating, blocking, and securing machines or equipment to control hazardous energy. Specific procedural steps for the placement, removal, and transfer of lockout devices or tagout devices and the responsibility for them. Specific requirements for testing machinery or equipment to determine and verify the effectiveness of lockout tagout devices and other energy control measures. Now, as I said before, the Review Commission in its decision held the General Motors written lockout procedure was too general to satisfy the specificity requirements of the lockout tagout section I just referred to. And the Commission, as we will look at here at the end of my presentation, refers to the OSHA Appendix A to the lockout tagout standard. Now, specifically in General Motors' case, the Commission found that GM's written lockout procedure failed to inform employees of the specific procedural steps to shut down and lock out a machine or piece of equipment. Further found the procedure did not provide any information concerning the machines or equipment at the facility, such as the types and locations of the machine or equipment, operating controls. Furthermore, the procedure did not include the means to enforce compliance, and the procedure did not include the name, job titles of affected employees and how they notify them, or how they're to be notified. By stating that GM's procedure lacked a number of specifics set forth in Appendix A, the Review Commission concluded that employers are required to develop written lockout procedures in accordance with the information contained in Appendix A. So the Review Commission is at that time telling employers that you had better be alerted to the fact that we have a regulation. It does require specificity, perhaps beyond what employers would like to have to comply with, but you had better start doing that. The particular facts in this case didn't just deal with a motor rail conveyor, dealt with other types of equipment, but I picked this one out. Contained 15 or 16 automatics, 165 weld guns, probably 300 limit switches, and over 150 disconnects, and for which at least 4 safety locks were necessary to lock it out. The Review Commission stated that the decedent, notice the word decedent, a journeyman millwright with 10 years of experience, was so concerned about his unfamiliarity with the conveyor that he told the supervisor he feared getting his damned head caught in that thing. Well, I won't get into details as to what happened, but you can imagine. So by stating that GM's written lockout procedure was inadequate regarding the complex machinery and equipment at the facility, the Review Commission concluded that employers are required to develop a separate written lockout procedure for complex machinery and equipment. And that last sentence I just read you from my PowerPoint is a good overview and summary of what OSHA's position generally is regarding equipment-specific lockout tagout requirements. You are required to have that for all what they call complex equipment and machinery. And again, that will vary from region to region on how complex OSHA will, or how OSHA will define complex machinery and equipment. But I can tell you in my experience, number one, that means that different in structure and operation equipment requires specific written lockout tagout procedures. Now, if you have 7 of the same machines, you only need 1 procedure for the 7 machines. And if you have, for instance, conveyor belts of different kinds, but they operate basically under the same premise and concept, you don't necessarily have to have a written separate lockout tagout procedure for like-kind equipment. But if your equipment is different in structure and how it operates fundamentally, you need to develop a beginning-to-end written procedure on how to lock out and tag out that equipment and, in the end, re-energize it. So a facility has to go through and they have to identify equipment-specific machines, and then they have to develop lockout, tagout, equipment-specific written procedures upon which employees will be trained, and I'll discuss that in a little bit. So a lot of employers haven't done that to the extent necessary. What a lot of employers are believing is that when they hire someone new and that new employee goes through orientation and training, the orientation and training includes a general course in lockout, tagout principles, but does not take itself to the floor where the machines are located, and employees are then educated on the specific lockout, tagout procedure for that specific piece of equipment that must be in writing. And then the employee demonstrates their ability to execute on the lockout, tagout procedure, equipment specific, and then signs off on that equipment specific lockout, tagout procedure so that the employer can provide evidence that the actual equipment-specific training was provided to that employee. It is not enough to simply educate, orient, and train on general principles of lockout tagout. You have to get to equipment-specific verifiable training as well. Now, not every employee in a facility must be authorized to lock out and tag out equipment. The most common group of people who are so trained start with maintenance employees in a facility, but it can very well go beyond that, depending upon the type of business you are, and you need to make sure other people are authorized to lock out and tag out equipment. But you can have unauthorized employees who are simply trained on the fact that they are not authorized to ever lock out or tag out, but they are trained with the general principles involved with lockout tagout, so they know what it means when you have a lock and tag on a piece of equipment and the rules that apply to that and so forth, and never to stick your hand or fingers or arms into energized equipment. Don't break the plane of that equipment, those type of things. But as employers decide who they're actually going to train to become authorized lockout tagout, you had better make sure that when push comes to shove, that if they are in fact involved with a piece of equipment that is being locked out and tagged out, that they have been equipment-specific trained with those specific written procedures in place that he or she is signed off to before they touch that piece of equipment for de-energization, maintenance work, etc. So the OSHA position is that employers must do more than just generally train people in lockout tagout and then assume that supervisors on the floor will at some point further train them anecdotally on equipment A or machine B, whatever. Now, the problem employers face are multifaceted regarding the Review Commission's conclusion that businesses are required to develop a written lockout procedure in accordance with this Appendix A that we'll be looking at. First, the lockout standard simply states that Appendix A serves as a non-mandatory guideline in assisting employers for compliance with the standard. Well, if it's not a mandatory guideline, why is it that OSHA would require that? Well, they're not requiring it per se, that you must follow the points mentioned in Appendix A verbatim, but they are deciding, and easily so, that if someone gets hurt, maimed, amputated, or die, you know, OSHA is going to come in and look at something and say an employer needed more of X, Y, and Z. And by the way, we even have an Appendix A that suggests what those should be. And OSHA has the high ground, starting out by always being able to be more critical of what was or wasn't the case by way of what the employer had in place in terms of a written equipment-specific lockout tagout procedure and program. But technically speaking, the Appendix A that we'll be looking at does not have a mandatory application, but for all practical purposes, that's how OSHA views it. I note in my comments that the legislative history of the lockout tagout standard, it stated that the standard is written in performance-oriented language, providing considerable flexibility for employers to tailor their energy control programs and procedures to their particular circumstances and working conditions. Now, that's where we come back to the performance-based standard upon which we judge the adequacy of written lockout tagout procedures. But a matter of interpretation is that what that really means, according to OSHA, is that employer A doesn't necessarily have to have the identical same lockout tagout procedures as employer B for the same type of equipment. It can be formatted differently. It will still need the essential step-by-step process of how you successfully lock and tag out a piece of equipment to de-energize it. But in the end, you have to have certain fundamental informational aspects contained in the written procedures in order to arguably say, this is what the employee read and was trained on. But the bottom line is that regardless of how an employer ends up drafting the lockout, tagout, equipment-specific procedures, by guys, you better have something in place for all of your machinery and equipment of any consequence. Some employers will say, well, we haven't done that, but how are we going to tackle that process? It could be hundreds of different kinds of machines and equipment. And that may be the case. And as an employer, as an approach to get started, start with your major pieces of equipment, and it may take you a while to get there, but you have to at least start, because failure by an employer to have a lockout, tagout written program and training process for its employees can reach the level of willful violations, which means that intentional, grossly negligent, reckless type of non-compliance that can result in up to $70,000 per violation. If someone should die as a result of a willful violation, the employer and managers can be criminally liable for criminal homicide under the OSHA standard. It is a misdemeanor offense, but you can go to jail and be fined as a result of your failure to comply with lockout tagout, if it's a willful violation. There are other problems with the decision in that the Review Commission never really defined what is meant by complex machinery and equipment. But again, complex is in the eyes of the beholder, and you can take two people with the same background, and one person, I think I use the engineer analogy, of 30 years experience thinks it isn't that complex, but a new engineer will say, yeah, it's complex, because he hasn't been around the block like the more experienced engineer. And so who do you believe? Well, getting back to the dumbed down theory, you're going to need to take that into consideration and dumb down the decision on what's complex or not to the lowest common denominator of your employee workforce and err on the safe side. And then when you are preparing the written procedures, you may want to consider, and I don't mean offensively, dumbing down the explanation so that it hits a lower common denominator of understanding. Because OSHA wants to make sure that all authorized employees are familiar with and understand how to safely de-energize and lock out machines and equipment. And the equipment itself, again, complex. If you think ahead and say, what happens if somebody has an accident on this piece of equipment because they didn't properly lock out and tag out according to what is required, you're going to want to include that machine or equipment into the complex category, even though it may not be. Now, again, you may have multiple sets of machines and equipment that are of a like kind, in which case I believe, as do many others, that you can have one more generalized lockout tagout procedure for like kind equipment. It's machines that are different in structure and operation from others, that really, in my opinion, mean that you need to strongly consider that as complex machinery and equipment needing specific lockout, tagout, equipment-specific procedures. I mentioned on this next slide that the Review Commission does not explain whether a lockout procedure for complex machinery and equipment must contain separate lockout steps for the different types of servicing and maintenance tasks performed on the machines and equipment. The Commission simply states that the amount of detail would depend on the complexity of the equipment and the control measures to be used. Okay, what they've done is not given an employer a real answer on how specific must be by definition. But again, if it's kind of a two-edged sword. If you are too specific, you know, right down to crossing every I or dotting every I and crossing every T, and an employee in an incident failed to perform step number 20 or 15 or whatever, you may decide that having too much specificity kind of boxes you in a corner. Having too little specificity may not be enough. So you're going to have to tailor the step-by-step description of how to lock out equipment accordingly. I can't give you a precise formula. I would generally say that you will want to err on the side of more specificity than not. Because under OSHA regulations, if you are cited for an employee not following lockout tagout procedures as verifiably taught and trained on, and that employee acts contrary to the policy, employee misbehavior is a defense to the employer's liability. Misconduct by the employee can be a defense. So if you find that an employee took shortcuts and didn't follow all the lockout, tagout, equipment-specific procedures, and there's evidence that they have been trained on the same and signed off for that training, you have a very good defense and might win that argument that the employer is not going to be held liable. Employee misconduct is a defense. So keep that in mind when you are drafting these procedures and making sure employees are trained in them and verifiably so. Now, before I get into Appendix A of the lockout tagout standard that I have, the basic concept is the number one, as an employer on lockout tagout, along with a myriad number of other safety programs, you really need to train and orient your new hires to the concept of lockout tagout before they hit the floor as a trainee under supervision. Hopefully that's the case. Keep in mind that supervisors will sometimes believe that, well, they've been through lockout tagout training and orientation, so they know about it. Well, they don't know about it because you and I know that new hires, even though they've been told something, don't retain the information. And number two, it's a whole different environment for them. And being rookies on the floor, they're going to be more subject to accidents and injuries because they're not familiar with the way things flow, the way equipment is run and operated, and it can be a scary environment for them for quite a while. So the first step is simply that, orientation and training of new hires. The second step is that as they go through their actual work orientation and training under supervision, if they have been chosen to be an authorized or potentially authorized lockout tagout employee, you're going to have to make sure that the equipment and machinery has been identified on your floor that equipment-specific lockout, tagout, or written procedures have been developed. You also have to make sure that annually, within the context of equipment-specific lockout, tagout, that one or more people familiar with the operation of that equipment have verified once a year that the existing procedures, equipment-specific, are still accurate and not subject to change. If there has been equipment change-outs in whole or in part with machinery, then there have to be new revised lockout, tagout written procedures created for that equipment. So in addition to having the procedures, annually those procedures must be certified by either a safety manager or someone who is familiar with the equipment, like a supervisor, that the lockout, tagout standard is certifiably accurate. Then you have to have the certification process carry on to employees who are authorized to perform lockout, tagout, that they sign off every year on the certified or recertified lockout, tagout specific equipment procedures. And then you have to make sure that the supervisors, when they are expecting an authorized employee to perform lockout, that in fact they have signed off within the past year on that equipment as to their verification and knowledge. And in the process of signing off on the equipment by the employee, that they know how to perform lockout, tagout, that they demonstrate the ability to perform correctly so the written lockout, tagout procedures. So in addition to having the employee review them and sign off, they have to demonstrate their proficiency. Now, it can be for employers a rather daunting aspect to comply with, but that means that you will have to have supervisor participation in this whole process and a manner by which they can access information in order to verify, if they don't already know, that this employee has been trained and signed off, timely so, to the lockout, tagout procedure. When we get into Appendix A of the standard under OSHA, I provide you with the wording so you can see how specific or not specific they really are. And you get to the purpose. According to OSHA, this procedure establishes the minimum requirements for the lockout of energy isolating devices whenever maintenance or servicing is done on machines or equipment. It shall be used to ensure that the machine or equipment is stopped, isolated from all potentially hazardous energy sources, and locked out before employees perform any servicing or maintenance, or the unexpected energization or startup of the machine or equipment or release of stored energy can cause injury. Now, keep in mind that those who aren't familiar with lockout, tagout realize that there's more than simply locking out the equipment with a tag, but the person is required to lock, tag, and trot. It's kind of a threefold effort before anyone attempts to break the plane and tear the equipment down and work on it. A lot of employee shortcuts, by my experience, has been not trying the equipment once they have supposedly locked out and tagged out the equipment. Now, there are lots of other issues associated with that, but it's really lock, tag, and trot, something that should be beaten into the brains of employees in the workplace. It's not just two, it's three: lock, tag, and trot. OSHA says that all employees are required to comply with the restrictions and limitations imposed on them during the use of lockout. And one aspect of employer reticence in this area is that there are times when they are not providing employee discipline for violation of lockout, tagout, equipment specific, or any kind of lockout, tagout for that matter. It's expected of employers that if employees violate safety rules and regulations, and especially lockout, tagout, that there be discipline. Employers differ in their severity of discipline depending upon their safety culture and what they view as appropriate. There are some companies where first offense failure to lock out, tag out after an employee has been properly trained and verifiably so, they lose their job. They don't get suspended without pay or anything like that. First offense is their last offense, they leave the facility forever. Other employers will suspend, retrain, whatever. Sometimes that even involves supervisor discipline for not properly supervising the employee's activities. Because remember, no matter how much you think an employee knows or is willing to follow by way of the rules, you're going to want to make sure as a supervisor that in fact they are doing that, which means that supervisors will sometimes need to review the process even though the employee has been verifiably trained on the procedure before the employee actually performs the procedure. A friendly reminder before the actual de-energization lockout tagout procedure is employed. Knowing the downside and how people can die and lose their fingers, hands, arms, legs, whatever, their head, as in the GN case, you would want to do that as a supervisor because if something bad happens, people are going to look to a supervisor and ask what they were doing in hindsight to help this not occur as a violation. It's kind of like trust with verify. Was that President Reagan's famous speech? The sequence, I don't know if I'll read all of these, but the sequence is important. Number one, notify all affected employees that you're about to perform lockout tagout. Authorized employee shall refer to the company procedure to identify the type and magnitude of the energy, understand the hazards, methods of control. 3, if the machine or equipment is operating, shut it down by the normal stopping procedure. You press the stop button, open switch, close valve. But keep in mind, another fallacy in a lot of employees' understanding is that hitting the E-stop is not locking and tagging out equipment. In fact, locking and tagging out an E-stop is not locking and tagging out as required under OSHA regulations. So don't let anyone be fooled into believing that emergency stop buttons are good enough. They're not. Deactivate the energy isolating device so that the machine or equipment is isolated from energy sources. And it says include types and locations of energy isolating devices. 5, lock out the energy isolating devices with assigned individual locks. 6, store the residual energy such as adding capacitors, springs, elevated machine members, rotating flywheels, hydraulic systems, air, gas, steam, or water pressure must be dissipated or restrained by methods such as grounding, repositioning, blocking, bleeding down, etc. And that even means if the process by which you bleed a system out will result in a very slow descent of an arm or a piece of equipment. It doesn't make any difference whether it moves fast or slow. You need to de-energize all these other potential sources of energy and allow the equipment to come to rest first. You know, you don't leave a hydraulic on when it can gradually come down. You have to dissipate that built up inertia and put it in the down position. 7, ensure that the equipment is disconnected from the energy source by first checking that no personnel are exposed, then verify the isolation of the equipment by operating the push button. Okay, that's your try aspect of lock, tag, and try. And when the equipment is finally locked out, tagged out, and they have tried to re-energize it, you have supposedly reached the locked out status. Now, attachment A also says that when the servicing or maintenance is completed and the machine or equipment is ready to return to normal operating condition, the following steps shall be taken. 1, the machine or equipment and the immediate area around the machine to ensure that non-essential items have been removed and that the machine or equipment components are operationally intact. Check the work area to ensure that all employees have been safely positioned. 3, verify that the controls are neutral. 4, remove the lockout devices and re-energize the machine or equipment. 5, notify affected employees that the servicing or maintenance is completed. And number 5 is actually quite a common omission on the part of people in the workplace. You know, there's a general lack of communication. Again, person X assuming person Y knows something. A good floor supervisor or manager of that particular activity will never do that. Never take anything for granted that people know what they know at any given moment. What must employer do to comply with equipment-specific lockout? I remind you, establish who shall be authorized as an employee to perform lockout tagout, develop lockout tagout written procedures for equipment-specific employee training, annually update equipment-specific procedures, and have employees sign off to annual retraining. Employees must demonstrate their understanding and ability to execute equipment-specific lockout tagout. 4, same or similar equipment may be included under one general lockout tagout written procedure, such as conveyor belts, multiple machines of the same kind, etc. Track initial and annual lockout tagout employee training and be prepared to produce written sign-offs if OSHA conducts an inspection. Keep in mind that OSHA is very heavily driven by the written documentation as evidence of employer compliance with safety rules and regulations. And they do cite a million different times for lack of adequate documentation and safety program compliance paperwork. So OSHA will show up at a facility, and one of the first things they do is look at paperwork. And they'll say, let me look at your lockout tagout program. And then they'll come in and say, let me look at this machine's specific lockout tagout procedures and employee sign-offs and training. And then they go to the employee and will ask them to describe what they're supposed to do in locking and tagging out a piece of equipment. And you'll be surprised when employees may not be very adept at verbalizing what they know they can do with their hands and their brain out on the floor. And some employees will even forget if they signed off. All the more reason why you want that evidence in their file that they were signed off on lockout tagout. So my conclusion is that compliance with the lockout tagout regulations means more than training employees on the general concept and the do's and don'ts. Verifiable equipment-specific training is required for an employee before he or she is allowed to perform work on the energized equipment. Furthermore, annual review and certification of lockout tagout procedures for all equipment is necessary to ensure compliance with OSHA's lockout tagout regulations in that regard. So if any of you are an employer who is lacking in being up to speed on what you need for lockout tagout training, equipment specific, you need to get started on that as soon as possible and make sure that you do your very best to avoid ever having an incident and then being accused of being a willful violator by not having what you need in place. And I would also preface this by saying that it will require some time and money and commitment, but it only takes one horrible accident to make you regret delaying efforts to get up to speed with lockout tagout in your facility. So that's my presentation today. Is there anyone here who might have any questions? Okay, if you are a facility that lockout tagout is relevant to your situation, please give that the proper attention. that it does need. And I thank you for your